Is the answer a qualified yes?
So the clip that you just played, I thought, was the most remarkable part of this entire argument today. And it's because of the former president's lawyer's response to the question, that very question, the hypothetical of a president who orders SEAL Team 6 to take out a political rival. Could he be prosecuted after he left office for that crime if he had not been previously impeached and convicted? The answer was really no. That was what his lawyer said. And that answer, I think, did not sit well with the judges. And for that reason, I think they are unlikely to rule in Trump's favor. So the question that remains is, how will the court rule against Trump? Because it did seem that they all three were inclined to rule against him. But there was not a clear message coming from the panel today about how exactly they would do that and on what basis.
Well, I guess that's our question about how this moves forward. These three judges, Professor, two Biden appointees and a George H.W. Bush appointee who replaced Ken Starr many years ago on this panel, were very skeptical of what they heard today. Where would it go next? We've obviously talked a lot about the Supreme Court, but there is a higher appellate court this could reach, right?
Well, this was the D.C. Circuit Court of Appeals, was a three-judge panel. After they issue their opinion, Trump could seek rehearing en banc. So he could ask the entire D.C. Court of Appeals to reconsider their decision. So the question would be, would he do that if they rule against him? Would he seek first to go to the United States Supreme Court, which he could do instead of first seeking en banc review? I think it's going to depend in part on how they rule. I mean, the first thing that I was interested in for today's argument was, how interested are the judges going to be in this question of whether they have jurisdiction to hear this issue on appeal now, before there's been a trial. There had been an amicus brief filed suggesting that the court did not have jurisdiction to hear what's called an interlocutory appeal on the question of immunity. Neither of the parties had briefed that issue. They just assumed that the court had jurisdiction. And so the first thing that was very interesting this morning was the court asked right off the bat about that question. Neither party embraced the position that had been raised by the amicus, that there was no jurisdiction. And the court, although it was quite interested, and I think, and concerned that it had jurisdiction, seemed inclined to go ahead and reach the merits of the case, perhaps under a doctrine known as hypothetical jurisdiction, that for which there is precedent in the decisions. And so that's the first question that the court will have to rule on, I think, is whether or not they have jurisdiction, and how they rule on that also could affect the trajectory. In other words, if they find they have no jurisdiction and they go no further and they don't consider the merits, they would be sending it immediately back to the trial court. Trump could again seek en banc review, that he could go to the U.S. Supreme Court, but that's sort of the first threshold issue that we'll be interested to see how they rule on.
Okay, so Professor, as this process plays out, however it does, what is the requirement of former President Trump as a defendant? Because he has said in fundraising emails in the last 24 hours that he was being forced into the courtroom, distracted from campaigning. Is there any requirement that he be in attendance? Did he have to be there today? Does he have to be at any others in the future?
He does not have to attend any appellate argument. And so it's disingenuous for him to say that Biden or anybody else from the government or from the special counsel's office was requiring him to be present in court today. He could have absolutely let his lawyers handle this entirely without his presence. There was no way for him to participate in today's proceeding. This was not a evidence-taking procedure. This was entirely an appellate lawyer's argument presenting to the court. So he could certainly choose to be present, but he was not required to be present. And that's going to be true at any appellate argument. And we may well see a good deal of those as this and other sort of purely legal questions work their way through the courts.
Just to be clear, that would also include closing arguments on Thursday at his civil trial in New York. Correct, Professor? He doesn't have to be there, but will be. So we'll all end up talking about him. I have to ask you quickly about what's happening in Georgia. Fulton County DA Fani Willis being accused of inappropriately employing a romantic partner as a special prosecutor against Donald Trump, and then going on vacation with this partner using money that he apparently made from the DA who authorizes his compensation. If these accusations are true, as brought forth in the Atlanta Journal-Constitution, what happens to this case?
Well, I'd like to read those filings. I have not yet had the opportunity to read the filings nor to see any supporting evidence. I don't think there has been any supporting evidence filed yet, and I'd like to read any response that the district attorney files. My biggest concern, based on the allegations thus far, would be the misuse of funds or the use of state funds for personal use, perhaps indirectly through this other prosecutor who's been hired. That is the issue that would raise the greatest concern to me. But again, I want to wait and see more here in terms of the supporting evidence, the arguments, and the legal authority cited going forward.